Board of Appeals meeting. I call this meeting to order. We are the Board of Appeals meeting January 14th, 2022, being held virtually using the Zoom platform. At this time, I would like to start off by having Corp Counsel Cody Friends review the Sunshine Law updates before I introduce the rest of our board members.
Good morning, everybody. This is Deputy Corporation Counsel Cody Friends. We're going to share the screen in a moment. Hang on one second, everyone. We're just getting an email out to board member Cunningham with the link, and then we'll be able to share screens. Did everybody get a copy of the PowerPoint presentation that Kim and/or April shared with you guys? Yes, great. So I won't read it all to you guys since you've had a chance to review it. I want to go through it and see if you guys have any questions. While we're waiting for that to come up, does anybody have any questions about the PowerPoint?
Only that its implementation has been delayed.
That's correct. Currently through the end of next month, but I wanted to get it to everyone so you guys were all familiar with it, just so that at this point we might as well start practicing getting everyone used to always having their cameras on at all times, getting used to the chair, our acting chair right now, Ms. Aguiar, getting used to doing a roll call for all of our votes, and especially important is during our executive session, making sure that if you're home, and everyone right now is via Zoom, if you're home, identifying anyone that's in your home and doing everything you can to protect against them being able to hear what's going on during executive sessions. So although we have a delay and it's not starting quite yet, and we don't know at this point whether or not the governor will further delay the start of Act 220, given the current surge that we're dealing with now. Should that happen, I'll let you guys know as well, but I just wanted to get you guys familiar with everything going on at this point. Any questions about the PowerPoint or the important notes that I've just made regarding the most important changes that everyone will need to be used to? No? All right, seeing none, why don't we actually, since we have parties waiting.
We have him now, Cunningham.
Great, and it looks like our newest member, there's Mr. Cunningham. Good morning, Mr. Cunningham. Chair, I don't know if you want to do a quick introduction to everyone. We do have a new board member, and that is Richard Cunningham, who is newly joined us. We apologize, Mr. Cunningham, you didn't have the Zoom link. But everyone, this is the new Board of Appeals member, Richard Cunningham, joining us now.
Good morning.
Welcome, Richard.
Aloha.
Hey, Richard, welcome on board.
Thank you.
Okay, are you ready first?
Why don't we go straight into the chair? If it's okay with you, since we do have parties waiting for the one hearing we have, why don't we take that out of order so that I don't know that Ms. Kekai, Deputy Corporation Counsel Kekai, and Mr. Myers need to see the Sunshine PowerPoint. So why don't we take their matter out of order and we can come back to the PowerPoint if necessary.
Perfect. So
okay.
I guess let's start with our introductions of our board members who are present.
Please.
So roll call, Stacy Aguiar, Vice Chair. Then we have Justin Lee, board member. Richie Henderson.
Present.
Neil Thomas.
Good morning.
Good morning. Springer K.
Here.
Morning. Matson Davis.
Good morning.
And our newest member, Richard Cunningham.
Present. Good morning.
Good morning. So that is our roll call for this hearing. And if I may just roll into our protocols, online protocols for the meeting. We ask that one person speak at a time with no sidebar conversations. When you are not the person speaking, if you can please keep your microphone on mute. Raise your hand if you would like to say something, and wait for recognition by myself before you can proceed speaking. Prior to speaking, if you can please state your name, speak slowly, clearly, and close to your microphone. Limit the distance of mobile phones or distractions, and if you can silence mobile phones and any other electronic devices when you're off mute. And we will take a break each hour, which is my recommendation, as needed. From there, we are going to proceed with the public statements portion of our agenda. Statements from the public will be, you will have 3 minutes to present what you want to. Cody, you will be keeping time on that? Perfect.
That's
So,
correct, but I don't believe we have any members of testifying publicly today, Ms. Aguiar.
great. So no public testimony. So let's start with new business. Our one agenda item is Ian Myers, PL-BOA-2021-000008. Appeal of decision by the Director of Public Works regarding notice of violation and order. Location is 75-437 Hualalai Road, Kailua Kona, Hawaii 96740. TMK is 3-7-5-017-008. Can I have each party introduce themselves and their legal representations? If you can introduce yourself and state your name for the record. First of all, can we have the appellant?
Hi, good morning. My name is Ian Myers.
Thank you, Ian. And you, is it just you representing yourself for this hearing?
Yes, ma'am.
Thank you. Good to meet you. And the appellee?
Good morning, board. Malia Kekai, appearing for Delilah Schluter, representing the Director of the Department of Public Works.
Good morning. And can we have, do we have to introduce the rest of the parties on the call, whether your video is showing or not, related to this hearing?
Yes, why don't we have, I believe we have 2 DPW representatives also present. If you could both state your appearances for the record, please. We'll start with you, Mr. Paz.
Good morning, Steve Halsey, Deputy Director of DPW.
Morning, Robin Matsumoto, Acting Engineering Deputy Chief.
Great, thank you. So to proceed, I do believe we have 2 different issues on this case. The first to start with the DPW's motion to dismiss based on statute of limitations of the claim. So if I can start out by first asking one of our board members to make a motion to hear that portion of this case. Neil Thomas is raising his hand. Yeah. Go ahead, Neil. You're on mute, Neil. Neil, you're on mute.
I have a couple of procedural questions, if I might. I understand that the first thing up is the motion to dismiss. May I ask if we are able to hear a motion on that if the appellant has not notified neighboring property owners? It looks like maybe they haven't. I know we had a case that created on this issue a couple of months ago.
Good morning,
Correct.
everyone. This is Deputy Corporation Counsel Cody Friends. You know, I have looked into the issue. We discussed it. I've read our rules of practice and procedure. I don't see anything that prohibits us from deciding a motion such as this, even though notice to the surrounding property owners has not occurred. Should the department not prevail on the motion to dismiss, we would need to continue the underlying appeal in order for Mr. Myers to properly serve his surrounding property owners. So that would be the legal opinion of Corporation Counsel, that we are able to proceed as to the motion to dismiss.
Thank you. That answered my second question.
Thank you.
Excuse me.
Go ahead, Mr. Myers.
Yes, ma'am. I'm not sure, but I did notice, I did contact my neighbors.
So, Mr. Myers, this is Cody Friends again. We won't get into that right now, Mr. Myers, because that's a separate issue that we'll address only if we need to. But I will just briefly say that the way in which you provided notice is insufficient, and the people that you noticed was also insufficient. But we'll deal with that if we need to, Mr. Myers. We're going to just deal with the motion to dismiss first. If we need to deal with that, we can further discuss that later on. Okay, sir?
All right, thank you.
Okay, great. Thank you. Go ahead, Chair.
So what I will do is present the understanding of the issue, which is limited to what's in the motion right now. So what we are limited in this motion at this time is that the appellant has 30 days to file a notice of appeal following the date of a decision. The director of DPW issued a decision. So the notice of violation, which was dated on March 1st, 2018. Then on July 27th, 2021, the appellant was issued a letter affirming the notice of violation, notifying the appellant of the director's findings. The appellant then filed his appeal with the Board of Appeals on October 24th, 2021, challenging the original notice of violation. So based on the board's understanding, we'd like to give the parties the opportunity to make any additional arguments in light of the motion. I need a board member to make a motion so that we can start the hearing.
No, Chair.
Chair, I'll move Neil Thomas to grant the motion to dismiss by the department.
Richie Henderson.
I'll second the motion.
Thank you. So given the motion at this time, can I ask if the appellant has anything they'd like to say, or do they want to present their position on this?
Yes, I have a few things to say. I sent in my paperwork. Did you people have a chance to read all of that? Did all of you have a chance to read it?
Yes, we have.
Okay. Well, the reason why it's so long is because nobody communicates and talks back with me. I've worked with the past mayor, and he has superseded that and waived the Board of Appeals and said that Mrs. Matsumoto would answer all my concerns and clarifications.
So
she never did. I went through every. Excuse me.
Sorry, Mr. Myers. Sorry, Mr. Myers. This is Vice Chair Aguiar. So the question that we are discussing, or this statement we're discussing at this time, is relative to your filing a Board of Appeals dispute, and are you disputing the notice of violation that you were issued on March 1st, 2018? If that's our understanding, that your filing
that's the beginning of it.
That the basis of your filing is disputing the notice of violation you were issued on March 1st, 2018?
It's the same issue, because I've had no communication. I've worked with everyone, 7 people, and they all up to Okabe, to Mr. Yamamoto, Ms. Matsumoto. They all failed to answer me. I had to go back and write the mayor, if you look in my paperwork, 3 times asking him to bring this to the past mayor, to bring this to closure, which I had no response. I wrote back, there was no movement. I continued to write to Ms. Matsumoto 100 days straight, asking her to please answer my concerns or clarifications. 100 days straight, no response. I've shown her everything. So I wrote to the mayor. It took me 3 times to Mayor Roth to get in. I finally had to call in, and they made an appointment. I talked to Mayor Roth. I met Mr. Paz, who was on the conference there. They sent that thing. They sent me the paperwork, but Mr. Mayor Harry Kim, he waived that thing until she said that she would answer my questions and concerns. And I brought the same answers and concerns, my questions and concerns to the new mayor. I presented to him. He never answered it. I presented to Mr. Paz, which I had to send a certified mail because they continue to refuse and address my concerns and clarifications from 3 years and put this Board of Appeals thing. I told him to please answer it so we can, I was hoping to clarify it within the department, not have to go out through all this because it's a quick fix. These people continue to not address my concerns and paint a room instead of answer it. And that's why I put in for the appeals, or else this thing would have never gotten to this board. It would still be sitting. If I did not bring this up continuously, it would have been forgotten and dropped to the side. Ms. Matsumoto is on the line. Ask her, because she knows. I've written to her numerous times. She addresses, but doesn't answer my questions. She dances around it. I wish Mr. Yamamoto was on the phone because he could answer the questions for us right away and clarify this. So my answer to you is that Mayor Harry Kim, she just waived this thing and said that I would have my answers and concerns addressed and answered. Not just addressed, but answered and bring clarity to my questions because it's a concern. And they're not. I'm questioning their policies and procedures. They're trying to put this on the side so they don't have to answer. I've been doing this for 3 years, asking them the same questions and not getting no answers. So is that the way they work? They don't answer, so that I don't have to. They don't have to answer me. Is that how it works? I got numerous emails.
Thank you, Mr. Myers.
Yes, so as far as I'm concerned, Mr. Harry Kim waived that. And when I talked to the new mayor, he said to work with Mr. Paz, which I did. I needed him to answer because the mayor would not answer those questions. Mr. Paz addressed him, but did not answer it. He danced around it. And that's when I went to appeals board because he refused to give me the clarification on it.
Thank you, Mr. Myers. We really appreciate your time coming in front of our board. We have, if I can say, the board members have all reviewed all of your correspondence and documentation that are going along with your filing to the Board of Appeals. And I do appreciate all of your time and effort being here. So at this time, we are addressing the basis of what your appeal is about and to establish your position, which, thank you, we've heard that. And if we may now hear from the Department of Public Works on their position of what we're hearing right now on their motion to dismiss based on an expiration of timeline.
Yes, thank you, Chair. The department's position is basically that there's no evidence on the record that Harry Kim waived any such timelines, and also that regardless of that conversation with the mayor, Mr. Aguirre had the responsibility to appeal prior to March 31st, 2018 and failed to do so. If he had a issue with the director's decision at that time, that was his opportunity to appeal, and he did not. Thus, he is 1,300 days late at this point. Even if you guys decided to say that the July 27th letter was a second decision or another final decision, he's still 59 days late. And thus, this case should be dismissed. Thank you.
So thank you, Deputy Corp Counsel. Do any of our board members have any questions for either party? Neil Thomas. Neil, you're on mute again.
I have to remember to hit the space bar, don't I? Sorry. One question for Mr. Myers. Mr. Myers, you did apparently meet with Mayor Kim. I see it in your memo from December 12th. Without pressing you for a specific date, can you tell us about when you had that meeting with the mayor and what he said about waiving or postponing the deadline? And did you get anything in writing to that effect?
Well, what I have, sir, I don't remember, but I remember the day I went was the day that the COVID started. So my meeting was held up. And he looked at the presentation and he knew that I was not getting the customer service. He said I was not getting the customer service. That's not what they represent. And I was not getting a response from Ms. Yamamoto. So he assigned and directed her to work with me one-on-one to bring all my concerns and to clarify them to me and to work with me. He assigned her to that, and I got it in my memo right there. Or else he wouldn't have said that. I even got it from Miss Matsumoto. She's over there. She heard him. She was assigned to work with me to make sure that all my things are just, and that never happened. The last time I showed her, there was an address reported on the NOV. I showed her a picture. I asked her, I said, do you see any grading? She goes, yes, I see grading. I said, would you go and investigate it? She goes, no. I said, why not? She said, because it's complaint driven. I said, well, this is the address that was turned in. And that was the last time I heard from Miss Yamamoto. Miss Matsumoto.
Thank you, Mr. Myers.
And I couldn't contact her after that.
Thank you, Mr. Myers. I appreciate your question, your answer.
Okay, and sir, I had no other way of getting her. I asked her to meet her, call her, I'd go down to the office. No response. I don't know what else I could do. I was begging her to meet with her and talk to her. She would not respond. And I have numerous emails. I got a whole load if you need to see them. I have all kind of documentation. I sent one or two within the meeting, sir.
Thank you, Mr. Myers. So if we can allow time, if there are any other board members with questions for either party. I have Justin Lee.
Thank you, Chair. My question is for the county, and that's taking Mr. Myers' argument, or I guess position at face value that the mayor waived the deadline. Does the mayor have authority to do so?
Thank you, Board Member Lee. The mayor would only have authority to waive deadlines if he was invoking some emergency powers, which I would say were not invoked in this instance. When an emergency rule is adopted or a proclamation is issued, then the mayor does have authority. But in this instance, the mayor did not have authority to waive.
But he did. I'm sorry, excuse me. Can I say something, please?
Yes, go ahead, Mr.
Hello?
Myers.
He did waive it. And if I know Miss Matsumoto is on the line, he waived it and he assigned her to my case. He reopened it. Ask her, please. She's right on the line.
Does the DPW would like to make further statements or a response or anything else that they may want to say?
This is Robin Matsumoto, DPW Engineering Acting Deputy Chief. Just like Mr. Myers says, I've been working with him since 2018 in various different capacities within the Department of Public Works as staff engineer, as acting building chief, and now as a acting deputy engineering chief. I did meet with him with Mayor Kim. Mayor Kim asked me to work with Mr. Myers. We did set up one face-to-face meeting. And at that point, I was told to get Mr. Myers into compliance. There was no mention of, waiving the appeal deadline. That discussion never came up.
I'm sorry, I'm sorry, can I reset? I gotta disagree because he assigned you, Ms. Matsumoto, to my case, so he reopened it. If he was shut, he would not reassign you to it. And did you tell them that you also said when I showed you pictures that you seen prior grading? Did you mention that to those people on the property?
So
Ms.
may I,
Matsumoto?
so may I redirect, at this time, it's the board's questions to both the appellee or appellant that need to be answered.
Okay.
So if I may have board member Neil Thomas, who's raising his hand, please ask your question.
Thank you, Chair. My next question, I think, might properly be directed to council for the board. I do remember that there are some flexibility in the board's rules about waiving certain deadlines and responsibilities. And so my question in this regard is, do we as a board have the right to waive the rule that says how long someone has to file an appeal?
Not that I'm aware, Mr. Thomas. I'm not aware that the board as a whole has the authority to waive the deadline, nor would I, separate and apart, just in general terms, recommend that the board ever consider doing so. That is a slippery slope. What you do for one, you need to do for everyone else. And so that is a, potentially dangerous territory to get into, but I am not aware of a rule that would provide this board the authority to waive that period.
Thank
It
you.
is a hard and fast rule. Yes, sir.
Thank you.
Can I also say something else, please? It's quiet.
I have one other board member who has a question. Mr.
Okay.
Mars, if you
I'm
can
sorry.
please hold.
Yes, I can.
Justin Lee.
Thank you again, Chair. My question is for the county. What was the reason for issuing the letter affirming notice of violation in July of 2021, if its position is that the date runs from the 2018 time?
Steve Housie, Deputy Director. I'll take that. I had the occasion to meet with Mayor Roth and Mr. Myers in June. Just so you know, I started in this position near the end of May. So early on in my role, the mayor got me into a meeting with Mr. Myers, and we attempted to begin a dialogue that the intent was to help Mr. Myers get into compliance with the original NOV from 2018. We had numerous email conversations and many exhausting conversations in that time frame that then led us to issue the letter reiterating our stance with respect to the NOV and providing additional, what I would believe to be irrefutable evidence to Mr. Myers that his property was out of compliance and that it was not a pre-existing condition like he attempted to tell us and explain to us beginning when I got involved in June. So the purpose of the letter was to provide aerial photographic evidence that he was in fact not in compliance. And subsequent conversations, as I've mentioned, long conversations, long emails, have attempted to appease Mr. Myers' concerns and decisions and questions about our position. And to this point, we seem to continue to be at an impasse. I don't believe we've ever addressed the meat of the issue, which is there is a situation of non-compliance. Mr. Myers is concerned about other matters that don't specifically address the fact that his property has been and continues to not be in compliance with our code. So, but the purpose of that July letter was to just reiterate our stance, which is your property is not in compliance.
Does that answer your question, Justin?
Yes, thank you.
Any other board members with additional questions for either party? And again, in relation to the determination of if this appeal was filed within the 30-day limit.
Can I say something, please, now?
Yes, Mr. Myers, you can have one last statement
One last.
before we present back to the board for a motion.
Okay, well, it should be more facts. I mean, before you make a motion, I've been waiting 3 years, and you're talking 30 days. I've tried 3 years, numerous emails, same questions. Got to Mayor Roth, talked to Mr. Paz. He sent that letter to me. He said, if I need to work with him, to please work with him. And I said, I want to try to work it because their policies and procedures are all wrong. If you guys read it, I should not even be here in the first place. I told him that the NOV is a complaint driven. It was an anonymous phone call and an address given that's not even my address. They tampered with it, put their TMK in that thing, falsified that information. Mr. Yamamoto also, I questioned him on the who, what, where, when, how did I get this NOV? He told me it was an address, which is not my address, an anonymous phone call. I wrote him again and told him, and he said, after 2 weeks talking to his people, he said, I told you just this address, an anonymous phone call. Not my address, not they put a TMK on top of there. And they continually hold back. It goes on from there. They don't want to answer. Nobody answers that question. How did that get there? 3 years. But I tried to work with Mr. Paz. He said to ask him. I asked him, he dances around it, doesn't address it. He addresses it, but doesn't answer it. I sent him a certified mail, and once I know that he's not going to answer the same questions I asked Ms. Matsumoto 3 years ago, I put in the Board of Appeal. Because he said to work with him, and I was working with him. I said, I want to get this so we don't have to go to the Board of Appeal. Please ask him, it's in my email. He said, okay, let's work. I was working with him, and I know he was the only one giving me answers. Ms. Matsumoto, once in a while. Mr. Paul's the only one was giving me, then he stopped giving me answers. I'm telling you, 3 years and 1 month. He told me to continue work. He said, if I have any questions, to work with him, and that's what I did. And when he didn't refuse to answer, when he did not answer my questions, I put in for the Board of Appeal right away. If you check my messages, you'll see I did not wait, I did not delay. I tried to get this fixed within the department because it's fixable. Apparently not. 3 years I tried, and you're telling me 30 days? 3 years of constant notification. Please, take a look at it again before you vote. And please realize the NOV is complaint driven. My address is not even on that. My TMK is not it, but they falsified it. How can that be legal? Should not even be here. And please look at the pictures. Pictures of the ones they got is from, I don't know where they got it from. But look at the other one. I've done nothing. It's all level. This used to be a subdivision. Miss Matsumoto stated that she's seen grading prior. She's not saying anything. Mr. Pauls, I worked with Mr. Pauls to answer the same questions I gave Miss Matsumoto and the mayor in July. I sent them the same. They chose not to answer it. Mr. Paz addressed it, but he did not answer the key question. The root cause is why was my TMK inserted on that report? That's all I want to know. They say past practice, policy, procedures. They're putting past practice policies are not and implementing them that are not even written down. It's not a written policy or procedure. They're making up their own. This is not third world. So that's why I'm saying I should not even be here. The address that was turned in, she saw, but they never investigated. Can you guys see something wrong? 3 years I asked the same questions. Nobody wants to identify it. But they want to go around it by saying the 30 days. It's really bad. And that's all I got to say before I get mad. I'm just saying, you have a problem in there with your training and everything that I'd like you guys to fix. If I did not question them on my wall permit and other things like that, other people would still be denied the services that they're required to have. I'm just thoroughly upset. Ms. Matsumoto, you know that too. I wrote you every day. 30 days, please, people, please. You need to hear my case because I'm one of few that is getting taken advantage of. They're using their own rules and regulations. That's all I have to say. Thank you. Please.
Thank you, Mr. Myers. Do I have any other board members with any further questions? And if we don't, I'm looking for a motion from any of the board members so we can go to vote. Neil Thomas?
I think my motion is on the table at present.
Sorry, can you repeat that, Neil?
I think you have my motion to adopt the motion to dismiss. That was seconded by Richie Henderson, was it? Yeah.
Yes. Richie, go ahead.
Because that there's a motion on the table right now, and I think that it would be apt for the board members to have a discussion prior to you calling for the vote. So if the board had any questions regarding this motion amongst themselves after hearing that, then I think that you would go forward with calling for the vote.
Are you asking for a guidance from court counsel, or are you asking for a vote to be called by board members? I think this is the discussion portion of it.
Yeah, so we have a motion on the table right now. And I think that Neil can restate the motion for the record, or April can restate the motion for us. And then I think what we need to do is just have some more discussion with the board members. And if there is none, then at that point, just vote on the motion that's on the table.
Correct. We have a motion at this time. Is that correct? Cody, we have a motion on the table at this time.
That's correct, Chair. We have a motion and a second, so this is currently now time for discussion. If there is any, if there is no discussion, then Chair, you can call for a vote by polling all of the board members.
So we're open for discussion. If anyone has anything further they'd like to say, please raise your hand. Seeing no other, oh.
I raised my hand.
I have.
Vice Chair.
Well, hold on, Mattson. We have Mattson Davis first, and then I will get to Richard Cunningham, who is also raising his hand. Go ahead, Mattson.
I'm restating some of the obvious here, but this is really about timing. And I feel for Mr. Myers, and I have understand the situation, but the rules, and I'm just trying to confirm this, and I do have one question, and that is that there is a specific timeline that needs to be followed as set forth to keep these proceedings going, regardless of conversations that are going on. These things must be documented and must follow the rules. And as we've been advised, going backward is an incredibly slippery slope that would probably open up who knows what. My question in some clarification is that the appellate's next step would actually be to take this to court on the subject that at hand, not on the 30 days, which is the question that we have. We're voting on 30 days right now. Is the rule been followed or the rule not been followed? The other part, which Mr. Myers has spent an extensive amount of time researching and writing, is really for him to continue on in the court system. Is that correct?
We are, the only discussion we're having right now is in relation to whether the appeal was filed within the 30-day statute.
Right. Okay, so my question about what would happen next is really moot and not to be spent any
Is
time on.
irrelevant at this
Is
time.
irrelevant, and that is up to Mr. Myers to pursue on his own at some further time. All right, thank you.
Can I say something before you have a vote? Mr. Paul said to, if I have any questions, to work with him, and I did. And I kept telling him, I'd like to work this before I put in for the appeals board. He never said anything. It's in I have my emails. I try to work to have it fixed. All they had to answer was the 4 questions. 4 questions, 3 years, no answer. He said work with him, and he refused to answer those questions. I sent him the certified mail. Once he did not answer that, I went to the appeals board. He's got the same questions the mayor said that you guys would answer. Nobody answered it.
Thank you,
Address this, but
Mr.
didn't
Myers.
answer.
I think I
3
have
years.
I have one other board member who has something to say, Mr. Richard Cunningham.
Oh, thank you very much. I think let me see the gentleman, Mr. Davis asked all the questions I was going to. So thank you.
Thank you. Do I have any other discussion or comments from the board? Seeing none, can I have a motion to move to vote?
Neil Thomas calls for a question.
I'll second Justin Lee.
Aloha, Madam Chair. I think we can call for the vote at this point, if that's what I'm hearing, which I can poll the members. Is that what your intention is?
Yes, please.
Okay, great. So we have a motion to grant the motion to dismiss. Mr. Thomas?
Aye.
Mr. Henderson?
Aye.
Mr. Cunningham?
Aye.
Mr. Lee?
Aye.
Ms. Kay?
Aye.
Mr. Davis?
Aye.
Thank you. And Chair Aguiar?
Aye.
Okay, the motion passes with 7 ayes.
So thank you. We have an approved motion to dismiss. I think, Mr. Myers, we would just like to thank you for your time. And at this time, the appeal coming before this board will not be heard, but we wish you luck on other avenues to address your issues with DPW. And thank you so much for your time and efforts.
Okay, I'd like to say thank you to the board for meeting, but I'm sorry, it's really sad where people don't see what's going on in the department over there. 30 days, 3 years. You guys have a great time. Stay safe. I appreciate your time. I will proceed in challenging this thing. Thank you very much.
Thank you.
Mr. Myers, before you leave,
Yes,
this is Cody, Deputy Corporation Counsel Cody, friends. We'll have the prevailing party, Madam Chair, prepare a form of the order, the proposed findings of fact, conclusions of law, and order. So Ms. Kekai, if you could let Ms. Schluter know between one or the two of you to prepare that order. You'll have 15 days, 30 days from today to prepare that order, and you'll serve the opposing party as well.
Will do. Thank you.
Thank you, Cody.
Thank you.
Okay, so next on the agenda, we move to the August 13th, 2021 meeting minutes. Have we all received those meeting minutes? Yes, Neil Thomas. You're on mute. Neil, you're on mute.
Sorry, I was just saying yes, that I've seen those minutes.
Okay, great. Can we get a motion to approve the minutes from a board member?
I so move to approve the minutes of the August meeting, but I do note that the agenda shows October 8th, 2021 minutes to be approved.
Thank you for the correction.
My apologies, Chair, that's my mistake. Sorry about that.
So correction, we are moving to approve meeting minutes from the October 8th, 2021 Board of Appeals meeting. Moved by Board Member Richie Henderson, and do I have a second?
Second.
I have a second by Mattson Davis. Can we move to vote?
Yes, Madam Chair. So we have a motion to approve the October 8th minutes. Mr. Henderson,
Aye.
Mr. Davis,
Aye.
Mr. Thomas,
Aye.
Mr. Cunningham,
Abstain, wasn't here.
Mr. Lee,
Aye.
Ms. Kay,
Aye.
and Chair Aguiar.
Aye.
Motion passes with 6 ayes and 1 abstain.
Great. Next on our agenda, we have election of the 2022 election of officers for our board. And I think we should roll right into that. We are looking for election of chair and vice chair for the 2022 year. So can I have a motion or nominations?
Nominations.
Richie Henderson.
Yes, Vice Chair, I would like to propose that you would be the chair for the 2022 year. I'd nominate you.
I'll second that.
Thank you, but I do want to open it up to see if anyone else is interested in chairing the board. Richie, would you be interested?
I was in the hot seat once already. Remember that my esteemed fellow commissioner, Mr. Thomas, was wanting to do that. So I would defer to him if he so chose to take on the responsibility of the chair.
Thank you for thinking of me. What you need to know, however, is that my term expired last month. I think the rule is that a commissioner with an expired term can stay on for 2 months as a holdover. So February would actually be my last meeting unless I'm reappointed.
Understood.
I do have an application into that effect, but I haven't heard anything.
Thank you, Neil.
Mr. Henderson, would you consider being vice chair and shadowing the nomination for Ms. Aguiar to be chair and kind of roll through this on another year and then see where Mr. Thomas might be next year after reappointment?
Yes, I would do that. Not a problem.
All right, so do we go to vote on chair and vice chair?
So we do have a nomination for chair, Ms. Aguiar, if you're agreeable, that would be voted on, but we also need a nomination. We have, sounds like a motion or a nomination for Richie Henderson to be vice chair. We need a second.
I would second that. Richard Cunningham.
And if we could have, if there's any discussion or objections, I guess we'd go to a vote thereafter. Stacy looks.
I will do my best, carve out the time that I need, and I appreciate, I will qualify it by saying I will appreciate Richie Henderson's backup as needed.
Great.
Thank you.
I just want to thank you for taking the time to take on those extra duties, both of you.
Thank you, Springer.
Thank you.
All right, we can call for a vote on, can we call for both, or do we start with chair first?
We can do both together. The motion is to approve Stacy Aguiar as chair and Richie Henderson as vice chair. So, I'll just start at Mr. Thomas.
Aye.
Mr. Cunningham.
Aye.
Mr. Lee.
Aye.
Ms. Kay.
Aye.
Mr. Henderson.
Aye.
Mr. Davis.
Aye.
And Chair Aguiar.
Aye.
Okay, you have 7 ayes and the motion passes.
Thank you. Also on our agenda is the status of appeals. Cody, is that a report by you?
Yes, it is. Good morning again, everyone. So we have one update that I would provide. It's the Deeringfield matter that the board was hearing in the interim in between the last hearing and the next anticipated hearing. There was a motion to stay the matter pending the circuit court case that's actively ongoing with the same parties. That motion was granted by the acting chair Henderson at that time. He did have the authority under the rules to issue an order that was non-dispositive, for example. So that case is on. An appeal was filed by Deeringfield's counsel, Ron Kim. There is a motion to dismiss filed by the Department of Public Works that's pending hearing in the circuit court in Kona, I believe Judge Kim. And I believe that that's being heard either later this month or in February. So come our next meeting, I will have an update as to the motion to dismiss hearing outcome.
Great, thank you. Outstanding petitions, if we can get a review of that by planning staff.
Aloha, this is April Supernaut. So just recently, a number of cases that were scheduled for the February hearing have been continued. And so we currently have about 6 petitions that are scheduled for the March hearing and another 6 that are currently scheduled for the April hearing. So it looks as though we will not have a February hearing.
Great, thank you. So jumping back to the Sunshine Law briefing, Cody, if you would like to give the board your PowerPoint presentation on that.
Sure. All right, everybody. So as I indicated earlier this morning, I won't read every single slide to you. We'll go through them slowly with April's help. And if there's something on any of the pages before you, I'd like it if somebody could speak up so that we can talk about it and I can answer any questions. These are going to, in essence, these are the requirements. The only change currently is that the effective date has been delayed, as we talked about earlier. The purpose of Sunshine, as everyone knows, is to ensure that the public always knows what's going on, right? This is protecting the public's right to know, allowing everyone access to what happens throughout our governmental process, so that there is transparency at all times for our public. Some of the notice requirements that are being changed, these are more specific to things that the Planning Board of Appeals and myself need to worry about, but we wanted to make sure you guys knew that there are lots of changes for notice requirements. One of the most tricky notice requirements is going to require that we have a remote location available to the public. this act created this requirement to ensure that people or community members that don't have the technical capabilities, such as they don't have internet access, they don't have a computer, for example, they still have a way to listen in and or join in the discussion if they want to or follow along with it. So it requires every board and commission to have a remote location accessible to the public. So that would be a room somewhere, for example, that they can go to and join remotely. So there would be a laptop, a computer of some form with internet access and a camera to join in if they want to. Again, this is not something you guys need to worry about, but I wanted you to be aware that that is something that the boards and commissions, county council, for example, everyone that does public hearings will be required to make available. So again, something on the more administrative side that will be done. Some of the agenda requirements, I won't go through all of them because this is agenda related. But if you guys have any questions about the agenda requirements, let me know. More notice requirements, you guys should already know, but if you don't, in order to get into executive session, at least for this board, there needs to be we need to explicitly articulate the purpose and the authority in order to go into executive session. There is a list of them under 92-5A. So we'd have to just make that record sufficiently before going into executive session. So this is more information about notice requirements. If you have any questions as to this slide, let me know. Any questions so far, board? All right, seeing none. Okay, we'll move on. Again, this is what we've talked about. This is kind of continuing what we've been doing. Initially, just for everyone's information, this was being done pursuant to the emergency orders and proclamations, but now we have an official law making this possible. So that's the that's what this slide is in essence referring to. And as I indicated, this is the remote location requirement that I talked about earlier, that we have to provide one. So as I indicated at the start of our meeting, in order for us to have quorum, it cannot simply be that we have quorum, but we have a black screen for 1 or 2 board members, for example. We always have to have everyone visible. Your camera must be on at all times. And that's, again, for the quorum of the board. Say we have more than quorum, theoretically, someone could turn off their camera. I don't advise that that ever occur. Should we have quorum and we have 2 additional or 1 additional board member that turns off their camera and then someone else loses a camera, we will no longer have quorum. So the better practice is, if you're a board member, always keep your camera on. And as indicated, as you saw today, what we did for the first time in a while, or at least what April did today, was call on the names of everyone. So your name is called, you have to verbally unmute, you have to unmute so we can verbally hear your answer for the roll call. And all meetings will be made public as has been the practice for some time now. So this is what I talked about. This gives you a little bit more specific information about the requirements when we're in executive session. And if there is anyone else in your home, in the room, they can't be in the room, quite frankly, but if they're in the house, we need to know who that is and where they are. And you have to take all steps possible to ensure that they cannot hear. So this is something that, hasn't begun yet, but should we have some technical difficulties, and part of this is going to tie into the notice requirements and what the agenda reads regarding connectivity issues. But if we lose a connection, we have to recess for the 30 minutes. If we don't fix that connection issue, we have to stop the meeting, and it would have to be moved to the next hearing date. Again, this goes specifically to how the agenda is written in the notice regarding that. I won't bother you with that right now. Should it become relevant, we'll discuss it then. But I just want you to be aware of it. This is basically what can, if we can reconvene if the following occurs.
Cody, but
Yes.
would we be able to reconvene in within the 30-minute recess, or if we lose connectivity, you're automatically in 30-minute recess, even if all parties reconnect and are online in less than 30 minutes?
Yeah, so the 30 minutes is basically, we have 30 minutes to figure it out. If
Okay.
we don't get it squared away, if we get it squared away in a minute, we can just reconvene. But if
Okay.
we hit 30 minutes, we're done. We have to cancel the meeting or wherever we're at and continue everything.
Cody, is that going to require a direction from the chair or vice chair, a motion from the board to recess when we lose a connection? Or is this law then automatically creating that recess to happen?
Well, I guess it'll really depend on the circumstances of that situation. If we lose connection and everyone has lost connection, we won't be able to make a motion, for example, to go into a recess. It would be an automatic recess, and I think that's where our Act 220 would come into play. If we lose, say, connection with enough board members, we no longer have quorum, then we could have the chair make that motion, for example. So it's really going to be circumstance specific, and we'll have to play that by ear when the time comes, depending on how many we lose, or if we lose the entire, say for example, we lose our YouTube connection, the ability for the public to see and hear what we're doing, then we'd have the chair and the board available to make that motion to restore our online connectivity, for example. But if we lose everyone, then we wouldn't have that ability. So it'll really depend on the circumstances.
Okay, thank you very much.
I have an additional question. So on that same note, because of the connectivity we may have connectivity challenges. If we're in the middle of the hearing, what if a participant or a appellee or appellant loses connectivity? Do they have the ability to come back and say, we need to do this hearing all over again because I was not allowed access to participate? Or is it based on the roll call that we establish at the beginning of the hearing when it starts? So even when you roll call people who are not visible on video, but they're connected by telephone call, that's our default attendee list?
It would be, but let's say we're in the middle of a contested case hearing and the appellant or the appellee, either one of them somehow gets dropped off, right? Either they lose their connection to us or we somehow drop them for whatever reason, for whatever technical reason. If either of the contested case parties is no longer connected, I do not think it would be appropriate to continue the proceedings. It is fair to say that whatever testimony and evidence had been elicited so far, that would remain in place, right? We'd have our record in place regarding what was done so far. And if we don't restore connection and we need to continue the hearing, we would theoretically pick up where we were. Everyone would be expected to remember what was presented, go back and watch the video up until the point of disconnection, and we could theoretically pick back up as opposed to starting fresh all over again, for example. Does that make sense?
Yep, got it.
Great. Any other questions on the video connection or any other issues we've talked about so far?
I have one quick question. Zoom has a chat function. Is there anything in these rules that prohibits sidebar chats of any kind?
Well, is the chat, just maybe as a technical question, April, is the chat accessible, visible to all participants?
Only if they choose all when they chat.
Okay.
So we recommend not using chat.
Right.
We use it administratively, privately, just to deal with technical things like changing names and, that kind of thing.
Okay.
But, we would advise not to use the chat as board members. If there's something to communicate that's relevant to the case, to do that openly, yeah.
That was going to be my thought. I just wanted to see whether or not anybody, for example, I can't hear. That would be more of a technical thing. I think that would be fine. Can you hear me? No one's responding to you. That would be fair so long as you send it to all. But if you have a question about the case, the facts, the law, that should definitely not be in the chat. So short of, can you guys hear me? I can't hear you, please hold. Something like that would be fine if, to communicate to someone you're having some technical difficulties. But anything legally or fact specific to anything on the agenda should not be put in the chat, for example. That way we make sure that our record is always made as to any questions, any comments for the board for our record.
Got it. Thank you.
Okay.
I wanted to question the audio visual
Okay.
portion of it, and that would be for specifically just for board members, need to be visually identified, or does that apply to appellants coming in? And how would that
It is
impact people dialing in on a phone?
It is specific to board members, so that the public that's participating knows that you guys are always there, right? The idea, I think, is showing its transparency again, so that our public who is joining sees you guys. If your camera's off, for all we know, you've stepped away and are doing something else on the phone, or, doing whatever else it may be that's interrupting your ability to listen to the evidence and testimony before you. So the idea is, and the rule is, board members. We, as you could see from today, Mr. Myers, for example, was on the phone, whether or not he has a smartphone that allows us to see him versus, because I believe he was a call-in and not a Zoom, for example. So they would not apply to them should they not have those technical abilities. We can offer them a location as long as we are able to make that connection in advance. We did offer that to Mr. Myers, for example, in this case. But until the act goes back into play, we're not required to, but we, April and Kim are making that available when possible. All right. No other questions? I'm going to move on to the next one. So again, these are the most important things to remember. Again, notice requirements, not all of them are going to be relevant to you guys. If there are issues where we have agenda matters that were not appropriately noticed, we will let you guys know, right? That would be, I would notify the chair that we have an issue and we can't hear a particular matter, or maybe we have an agenda issue where we can't even proceed. That's something that you guys would be notified about. If you guys have specific questions, this is how you get in touch with Office of Information Practices, which is what's controlling our sunshine law. If you have other questions, you can always call me as the attorney for the board. Call, email, whatever works best for you guys. Do you guys have any questions today? Any other questions today?
No.
All right, hearing none or seeing none, I'll send it back to you, Chair.
All right. Thank you, Cody, for that. Do we have any other announcements from anyone? Seeing none, I would like a motion to adjourn, or does it require a motion?
Yeah,
So
move to adjourn.
All right, I got Richie Henderson moving and Mattson Davis seconding. Motion to adjourn.
We have, if you could call for a vote, Chair, and in this, okay. In this case, if it's all in favor, for example, if we have anyone dissenting and we need to have more discussion, then we can do a polling. But otherwise, we'll have the chair for closing the meeting to just check if all are in favor.
Great. If our board members are all in favor of adjournment, please raise your hands. I have all hands raised. Thank you. Welcome, Richard.
Thanks, everybody. Happy New Year. Welcome
Happy
to
New Year.
2022, babes.
All right.
Thanks, guys.
Thank you, everyone.
Bye.
We will tentatively expect to see you in March of 2022.
Thank you.
Thank you.
Thank you. Have a great day. Happy Friday. Bye-bye.